Thank you for joining us today and welcome to the Social Selling News webinar. My name is David Bland. I'm the publisher of Social Selling News. Today, we're going to be talking about a recent win for the Federal Trade Commission against a direct seller that was found to have engaged in pyramid scheme activity, as well as other violations of the FTC Act. Furthermore, the commission is trying to leverage this decision in their pending case against Neora. So several interesting things to talk about today. After this discussion, my guests will welcome your questions, so please submit those in the chat section as we go. To discuss the implications of this case, I'm thrilled to be joined today by two experts who are no strangers to matters of compliance, as well as the FTC's ongoing actions against network marketing companies. First, I'd like to welcome Donnelly McDowell. Great to see you again, Donnelly. Donnelly is a partner in the Washington, D.C. office of Kelley, Drye, and Warren, LLP. Donnelly's practice focuses on all aspects of advertising and consumer protection law. He regularly represents direct sellers and others before the FTC and provides regulatory advice and risk mitigation strategies to direct selling companies related to earning and products claims, compensation plans, and compliance programs. Thanks for joining us, Donnelly. Next, I'd like to introduce Jonathan Gilliam. Jonathan is founder and CEO of Momentum Factor and FieldWatch, the leading global provider of brand safety and compliance monitoring services for direct sellers. In 2009, Jonathan co-founded a health-focused direct sales company where he first learned the importance of compliance, which led to the creation of his firm's FieldWatch compliance management platform. Prior to that, he spent 7 years at Deloitte Consulting, helping launch that firm's global anti-fraud product. He also co-founded an internet security software company. Jonathan is a regular speaker and thought leader in the channel, and I'm delighted to have him here today. Welcome to you both.
Thanks, David.
Let me start with a brief overview of this case. So in May of this year, a federal court in Arizona sided with the FTC in shutting down a direct selling company called Success by Health. Led by James Noland and 3 other defendants, SBH, as well as a company called Voz Travel, sold coffee, nutraceutical, and travel products between 2017 and 2020. After an 11-day bench trial, this Ninth Circuit Court found that Success by Health and Voz Travel were operating as illegal pyramid schemes, as well as making misleading earnings claims. The court also found Nolan in contempt for violating a previous settlement with the FTC, banning him from participating in future pyramid schemes. Donnelly, let me go to you first. Many of the violations mentioned in this case seem to be quite blatant, especially against the backdrop of a previous settlement involving similar allegations. I think there are many valuable insights here for companies who are interested in staying off the FTC's radar and investing in training and compliance. What are your major takeaways from this case?
Sure, thanks, David. So I wonder if many folks on the webinar had a similar reaction initially to me, which, candidly, I kind of brushed this one over when I saw it come through because there are so many negative facts at first that it really does seem like a slam dunk for the FTC. I don't think many folks were surprised by this decision. Really, it caught my attention more, and I spent more time with it when the FTC, in my mind, basically tried to mischaracterize it in filing a supplemental motion in the pending Neora matter. But that said, there are certainly some bad facts, but there's also some important takeaways. I don't know that it fundamentally changes much, but it does reiterate a number of points that I think you and Jonathan and myself and others have talked about fairly regularly amongst the industry. So I'll give 3. First, claims issues are really central to any pyramid case and any direct selling case. They're where the FTC starts. They're often where the FTC becomes interested in a company. And, there were a number of negative claims here. The low-hanging fruit of yachts and cars and piles of cash, exotic vacations, things that, really should never be made. And then there were a lot of claims emphasizing aggressive recruitment and inventory loading. Others get out of your job in 6 months and attain financial freedom in 18 months. I know Jonathan's going to talk more about claims issues, but I think my first takeaway is, really we should be starting with claims. It's often what piques a regulator's interest, whether it's the FTC or a state AG. So really important to pay attention there. Second point, I think, and this shouldn't be news, but I do think it's an important emphasis that the FTC really expects some mechanism for retail sales validation. And if you don't have a direct method of retail sales validation, you really need to have policies and procedures in place for preventing inventory loading, basically establishing that there's genuine demand and consumption for the product. Here, there were a number of negative facts that the court really relied heavily on in determining that Success by Health was a pyramid. There was no method of tracking retail sales. There was no 70% or 10 customer rule. And you had a series of statements by the court really honing in on that. They credited Dr. Bosley's expert, who's the longstanding expert of the FTC. They're also using in the Newer litigation, as proving that, but really they didn't. Success by Health and Nolan didn't do much to disprove it, right? So it wasn't a particularly disputed fact. And then the last and related point I'll make as far as takeaways is just the dangers of claims and comp plans that are really centered on recruitment. So thinking through how you're characterizing claims, both claims made in the field and claims the company itself made, were really recruitment centered. And one example of that the court talked about at length was what the company called 4 steps to success. And kind of each of those steps underscored a red flag of, longstanding FTC direct selling precedent. So the first one was getting started, and there the company encouraged really significant upfront business packs that cost up to $2,000. So heavy upfront fees, always something that the FTC looks at, particularly if they're not refundable. Auto shipments was the second part of the 4 steps to success. Use, sample, and sell was the company's policy. So auto ship is always, everyone uses auto ship, including Amazon and non-direct sellers. It is a common practice that is consumer friendly in many ways. So it's not to say that auto ship is certainly not per se illegal, but it's just that you need to watch how you're doing it and watch what percentage of sales constitute or comprise auto ship. And then the third and the fourth are related, and they're the company's third and fourth steps were building a team and then training and duplicating, including through what the company branded as the power of 10 bonus. So doing everything 10 times. So each of those, I think, really underscores red flags that we've seen in a number of precedents over time related to pyramid cases.
Absolutely. It really was a top-down violation, it seems, not just what the field was saying, but material that the company was putting out in black and white, which was certainly blood in the water for the FTC. Jonathan, let me ask you, this court determined that despite the defendant's use of disclaimers, the net impression was that affiliates could reasonably expect to earn enormous payouts. What is your advice to direct sellers when faced with training and educating their sales force about this subjective concept of net impression that the regulators are using to evaluate their recruitment methods?
Sure, I'll take that. So thanks for having me, David. Appreciate it. And Donnelly, good to see you. The FTC's net impression refers to the overall impression that an ad or post makes on its audience, right? So it basically says that posts and ads shouldn't mislead consumers about their commercial nature, mislead. So that you could have a post that looks like editorial style content, somehow this is my life and I happen to be drinking this particular product. But if it's a commercial nature, if it's meant to sell, it should be explicit that it's an ad, right? That's kind of the FTC's take. So it's kind of a sticky one, right? Because it often seems that this is in the eye of the beholder, right? So you don't, some people may see an ad, others may see really good content. So it's one of those things, but the FTC has been clear that companies should mislead consumers with disguised ad content, right? So you should be able to look at a post and know its intent, even though you just don't know, right? It's almost a feeling of whether it's meant to be a sales piece or not. If it's intended to sell, it should be explicitly stated as such.
Gotcha. Well, let's drill down a little bit more on that topic of disclaimers. What are some common mistakes you see with disclaimers, and are there any product types where companies need to be particularly careful with these notices?
Yeah, so disclaimers are really important, especially for like weight loss products or vacations or car bonus incentives. Almost all of these posts require at least a disclaimer, such as like before and after pics in the case of weight loss, right? So companies need to know how to use them properly and when the post needs to be just completely updated or removed instead. The DSSRC earnings claim document goes into a lot of detail on this, on how to use them properly, but they're really important when it comes to these kinds of claims. They also need to be visible and user-friendly. You know, in many cases, the font's too small or the color makes it not visible. And many times this is by intent, right? Folks don't want to show that they're selling something or have a disclaimer that just doesn't apply to you, but we know it may not be typical to everyone. And that's kind of the test. Is this something typical that I can expect coming into this opportunity or buying this product? We recently suggested to a client that they redo their disclaimer because it was just so long, reps couldn't use it, right? So it needs to be friendly and usable. You know, we're in discussions with many of our clients about whether it's okay to just hyperlink to the disclaimer and whether that absolves the risk at all. This might be a better question for Donnelly, but my guess is no, that you need to have it in the post somehow. So, you know, basically disclaimers need to do their job, which is to disclaim a claim, right? So if the results aren't typical, it just needs to be stated that way.
Right. I mean, we've got so many considerations, not just content. We've got font, we've got sizing, we've got hyperlinks, visibility. I mean, what's the bottom line here, do you think, if you had to sum it up?
The bottom line, I think, well, let's just talk about net impressions. The bottom line is companies like really need to ensure that that impression that's left by their social posts and ads is clear and transparent and doesn't blur the lines between advertising and editorial content. Monitoring for phrases and keywords from distributors and education on the concept of net impression is really important. It's kind of an obtuse concept for a lot of people, but I think there are some easy ways to teach it. Like, look, if you're meaning to sell the thing, it should have a disclaimer on it. So I think that's the message to the field. If you're trying to promote your product or opportunity, you know, it doesn't really matter how you do it. If it's an ad according to the FTC or EU regulators, at least, then it needs to be disclaimed.
Right. Donnelly, anything you want to add to that? I mean, when you're advising companies, there are certain things that have to be in the disclaimers, but like Jonathan mentioned, if they get too long, it's self-defeating. How do you walk that line?
Sure. So a couple points to underscore. I totally agree with what Jonathan said. I think, first of all, just nomenclature wise, I think some people say disclaimer and some people say disclosure. I usually say disclosure because to me, disclaimer says, and the court uses disclaimer, I believe. So, but disclosure to me goes beyond just disclaiming, right? So, and that's I think the reason that it's appropriate for this case is it really was a disclaimer, right? It was, hey, we're showing you these jets, but it's not guaranteed. So don't think that these aggressive income claims are in any way guaranteeing what you're going to achieve. Contrast that to a robust disclosure like those encouraged by the DSSRC guidance that Jonathan mentioned, that we've talked about in DSA certification program that we're involved with. And, you know, those, I think, contrastingly, they should succinctly disclose what is generally expected, right? And the idea of can you hyperlink, I think is a tricky one and depends on you know, the claim you're attempting to qualify. I think the FTC would generally say no, a hyperlink itself is not going to be enough. You could hyperlink to enhance a disclosure, right? So, you know, if you say generally most first year distributors earn X amount of dollars, for more information, see the disclosure statement here. I think that is kind of the archetype of a good disclosure, right? And that it discloses what is generally expected, and it refers the consumer to more information, to a place where they can attain more information. What you don't want in a hyperlink is, see more information here without saying anything else, right? So it might be that, there's not one particular typical income that can, a company feels comfortable giving in the disclosure just because of the variability and experience. But all that said, I think the disclosures or disclaimers at issue in this actual case were really, they were in mouse type font at the bottom of the page. They were really just saying, don't expect what the incomes represented. They really were not following best practices. And then the one other point I want to make is, disclosure only goes so far, right? Even the best disclosure is not going to cure a picture of a jet saying you can achieve this, right? And this is something we've seen in the number of FTC cases. You see it in the Herbalife settlement and the prohibition against lavish lifestyle claims, regardless of whether there's a disclosure. Jets, mansions, yachts, those are the types of things that no matter how, if you attempt to qualify them, they're going to be seen as misleading.
Absolutely. Donnelly, one question I have for you. The FTC sought over $1 million from these defendants for violations of the merchandise rule, also the cooling off rule, were specifically brought up and discussed in this trial. Do you want to give us a brief explanation of those rules and why direct sellers need to be aware of them?
Sure. So at a high level, the merchandise rule has been around for a long time. It came out in 1975. It requires sellers, initially it was called the telephone rule because it was when everyone was ordering things, telephone merchandise rule, or the mail order rule, I should say, and then it became the telephone rule, and then became the merchandise rule when it rolled in internet. But it requires sellers to have a reasonable basis for the stated time frame for delivery. And if they don't state anything, then it's assumed to be within 30 days of the promised time frame. The issue here was the company was selling products that didn't even exist. So, not great. And
quite an achievement, though.
What's that, Jonathan?
Quite an achievement, though.
Yeah.
So the product doesn't exist.
Right. So, you should have a reasonable basis for the shipment times, and the product should certainly exist at the time that you're selling it. And then, so that was a mechanism that the FTC sought to get money, right? Because in the post-AMG landscape, it's harder to get money. Although here, as you mentioned, David, there was a contempt proceeding or a previous order that allowed the FTC to pursue money through contempt, which is ultimately how it got money. But then real quick, just the cooling off rule, since you also mentioned that. The cooling off rule is sometimes called the door-to-door sales rule too, because it basically applies to sales not made at the seller's primary place of business. But it's not just the home. It could be a temporary location. It could be a hotel. It could be a convention center. But it only applies to sales over $130 at temporary locations, or sales over $25 at your house. But here, the startup packages were such that they were big enough that the FTC could kind of bootstrap in the cooling off rule as an additional allegation. So that's exactly what they did. They did it, I think, in part because they weren't sure how the court would rule in the contempt proceeding on money. They ended up winning on the contempt proceeding for violations of the previous order, and that's how they got money. And the court said that the FTC failed to reasonably approximate the damages associated with the violations of either of the merchandise rule or the cooling off rule. Ultimately it didn't really matter because they were getting all the money they were asking for through the other allegation.
Absolutely. Yeah, it seemed like, the chances that companies are going to be really nailed on one of these rules are certainly there. It's not something to shrug at, but in this particular case, they use that contempt order to really to get the significant sums from the defendants. Jonathan, your company is on the front lines of brand safety. What were your takeaways from this decision from a compliance perspective?
Well, I think many people on this call will remember that the term financial freedom has been at risk for a while. That started with constant complaints back, probably 5 or 6 years ago from truthandadvertising.org and Bonnie Patton. So as a result of that, regulators finally started cracking down on it. And I think this order basically cites the term financial freedom, I think it's more than 30 times or something, in describing the deceptive income claims made by the defendants. So they clearly do not like this term. It's finally being shouted from regulators and from the courts. There should be no doubt about this phrase in the channel, financial freedom. And I'd say it's effectively banned now. You just can't say those words. It's just, for some reason I don't like it. Maybe it's because of the history on it. Maybe it's because it's been so many years, but they brought it up a lot in this case, and they were successful. So that's that. A new one we're seeing a lot of is time freedom, right? And I don't know if folks on the call have seen this particular phrase, and that may carry similar weight with regard to promises being made. I'm going to get more time because I've got money coming in from this opportunity, and I can, that's something that we've always said in the space, and that one seems to be coming up, and it's still a bit murky. So time will tell with that.
Absolutely. Donnelly, after the trial, the FTC submitted what's called a notice of supplemental authority to the U.S. District Court in Texas that is adjudicating the ongoing FTC case against Neora. Tell us about this submission, and do you think it could affect the Neora case?
Sure. So I think the submission, as I said in the intro, is what initially made me go back and read this case, because I was like, wait, what? How is the FTC characterizing it? Or reread the case in more detail, I should say. So they made 4 points, and then we'll touch on Neora's response also. But they said, first of all, it supports the credibility of the witnesses that they're using in that case. So they're using 2 of the same witnesses, Dr. Bosley, who they've used for years, and Elizabeth Ann Miles. Obviously very different cases. Also, Success by Health didn't have their own experts. They didn't really attempt to refute many of the positions taken by Dr. Bosley and Ms. Miles. Nonetheless, the FTC basically said, well, this court found them credible, so they're credible. I think the more interesting substantive point that they attempted to leverage is this, I think most people familiar with the New York case will know that the FTC is really trying to push the envelope as far as what they characterize the standard, the longstanding Cascott standard for what constitutes a pyramid. And they characterize the Success by Health Nolan case in this supplemental motion as supporting the fact that the pyramid can be found where participants can only succeed based on recruitment. That's not phrasing used in the decision. So I think that characterization is odd and certainly a stretch from my perspective. And then they noted a number of the things that we started out the webinar by talking about, right? So the alleged disconnect between payments and retail sales, emphasis on recruitment over retail sales, push for starter packs, the people buying products at the end of the month. So some things that are not particularly revolutionary and highly fact specific, but they pointed to them as allegedly supporting their position in that case. And then the one other thing I think is particularly interesting. So they said the Success by Health case also goes against Neora's position that primarily based on retail sales versus recruitment has longstanding been the standard, and versus the standard that they're espousing in the Neora case. And while I think they reference primarily once in the decision, the Success by Health case, they use very similar language, right? They use largely based on product sales versus recruitment. So query whether it actually really matters. And then they also just touched on the proper test for misleading claims, as Jonathan was talking about, and the means and instrumentality standard, but they don't say much substantively there. And then I started to get into Neora's response, but I think, they basically said, look, these are highly fact-specific cases. They pointed out the multitude of differences. Success by Health, I think most notably, really had no mechanism of tracking retail sales at all, whereas Neora has quite a bit of data from years of drop shipping to customers. So I think you really have the FTC here trying to make an apples to oranges comparison and saying, well, look at this. But at the end of the day, I don't think it's going to be compelling to the court. I would be very surprised. It's a victory, but it's a victory under really completely different circumstances and facts.
In terms of the cost cut rule or reference, do you think it moves the needle on the overall view of cost cut?
I really don't. I think it's an application of a longstanding standard and a pretty clear-cut application based on the facts of the case. And you have so many adverse facts for the company that were at issue in this particular case that it's hard to extrapolate that to closer calls. And you can try to cherry pick some language from the decision, which is effectively what the FTC was trying to do. But each of these cases they're so like all pyramiding cases, right, are so highly fact specific. And I think that's the whole idea of standards like the Cascot standard, is that they're able to evolve to these highly fact-specific standards, right? And you allow a court some flexibility in determining how it should be applied and evaluating potential consumer harm. And I really don't see any element of this case as really, I think it's a good reminder for the industry of like what types of things the FTC is really looking at and is likely to pique their interest. But I have a hard time seeing this case as one that's going to be regularly cited going forward, just because it is so uniquely, decided on its facts.
Absolutely. That was my next question. Actually, do you think it's going to be cited in, any significance moving forward? But it sounds like it was the facts at hand are just so blatant with the violations that it's more black and white and not necessary to cite moving forward. But I want to remind everyone, if anyone has any questions for our guest today, to type those into the message chat section, and we can ask those. In the meantime, Jonathan, anything you want to follow up on regarding the kind of the overall actions of these defendants, where again it was kind of top down, not only something that oh, that was the field making a mistake, we need to train better. No, these were actual instructions coming from the top about how they wanted their field to sell. So some big red flags there.
Yeah, I think this company was pretty easy pickings for the FTC, right? I mean, they were making some serious mistakes. And it so happens the founder had been censured by the FTC many years ago, and was that's the reason for the contempt order, obviously. So these guys were pretty easy targets, and the fact that they could lodge this contempt issue with them meant that the FTC would recover funds as well. So a good one for them. But like Donnelly said, I think if they can't be cited, if this case can't be cited that often, that's maybe a good thing for some companies who are trying to do it right. But in the end, yeah, this was a pretty easy one. I think going back to the phraseology and the financial freedom, it's still a problem. It's using those phrases. It's a matter of, I think for companies, it's a matter of proactively looking for these words and phrases being used online and educating the field about them, right? The problem is especially in financial freedom always comes up with our clients. It's like, why can't we say that? We're giving people financial freedom. One of the problems we have with that is that there are mainstream companies all over the place, B2C companies that use it all the time. I've got a credit union here in Austin that has a big billboard and it says financial freedom, like the big headline on this billboard. And I drive by it going, that's a claim, but I don't know how my credit union is going to give me financial freedom, but probably less so than my favorite direct seller. So, but in our space, it just seems to attract more negative attention from regulators, and it's just something we've had to deal with. And again, we have the time freedom one that's coming up. So I think other issues like right now, like during this season, we're seeing a lot of issues around incentive trips and vacations not being fully disclaimed or disclosed, so that with a lot of folks at conventions and traveling, companies may see an uptick in activity right now with regard to claims coming from like promising trips, or these, you can easily get this trip to Fiji if you just join our opportunity, those kinds of things. So the world of compliance is rich and robust with lots of things that people can do, but those are the kinds of things we're seeing right now that are especially problematic.
Yeah, definitely some landmines companies need to watch out for. We've got a few questions for you guys that have come in. Let me start there. First one says, for ads versus content posts, if our distributors sell a craft product and show the things they are creating so their customers can purchase the items, are you saying that they need to show the finished artwork, include a link to the personal e-com site, and then add a note at the bottom that says this is an ad because they are trying to sell that product? Or an ad, in quotes, if they are showing something they were able to purchase or based on their participation in the comp plan of the company they're selling for. So what's the distinction, ads versus content post? How to approach that?
I'll leave that for Donnelly, actually. That's a legal question.
I think, so look, if something is clearly an ad, you don't have to disclose that it's an ad, right? Or if you're selling a product, you don't need a disclosure saying I'm selling this product, right? That's readily apparent. I think the point that Jonathan was alluding to earlier is that you could have certain content where it's not. So if you have an article that's really an ad, or an Instagram post that's really an ad, then, or you're using an influencer, then you could have then it could be necessary to disclose it's something an ad. Tends to come up less frequently in direct selling cases, to be honest, because usually it's pretty clear that someone's either a distributor or a company's selling a product directly. But there's been a fair amount of enforcement around influencers, or you have testimonials where it's not clear that it's an incentivized testimonial. But you certainly don't need to add a disclosure on a page selling a product where it's clear.
And you mentioned hyperlinks. Another question came in about the use of QR codes that link to the full disclosures in cases of limited space. I assume same concept, same rules apply when you're linking in any way to a larger, more thorough disclosure. Is that correct?
Yeah, I would group that. I mean, they're really very analogous, and we've seen this come up in other areas too. There was a rule on disclosing bioengineered food ingredients and the capacity to use QR codes there. I think the short answer is, for something like an earnings disclosure, you should not rely solely on a hyperlink or a QR code, right? Because the FTC's position is always going to be, and I think candidly they're probably right, most people are not going to click on the hyperlink, and most people are not going to scan the QR code, right? So it's one thing to enhance a disclosure with a QR code or a hyperlink, and it's quite another to rely on it exclusively.
Jonathan, a follow-up for you. You mentioned, now that financial freedom is kind of more or less an official no-go, right? What's the most efficient way for companies to blast this to their employees, to their field, to their affiliates? Because ignorance is not a defense here, and when in the age of being able for the FTC to be able to quickly monitor for certain phrases, what is your recommendation there for specific no-go phrases like that?
Well, we always say here, find it first, right? Prevent it from going out is helpful, and that's education, that's training, that's technology on posting apps and such where you can kind of catch those words before they go out. However, yeah, so you want to find it before it ever goes out, hopefully prevent it from going out. But if it goes out, monitor for it and collect it. I'm not sure I answered the whole question there, but the idea that you can just kind of let it happen and kind of wait around and hope someone tattletales on someone else and you find a violation, especially the ones that are really kind of hot buttons for the FTC for whatever reason, are kind of, those days are gone. So I think it's really just a matter of being proactive, monitoring, enforcing, making sure that people take things down when they promise to, they don't do it again, those kinds of things. So there's a lot of hand holding with the field to ensure that they really kind of follow the rules. And that applies to any and all claim words, which are, in the hundreds, of course.
Absolutely. Donnelly, here's a good question. How do you handle disclaimers on social media posts? Do they have to be on each post, or is a disclaimer in the bio or landing page sufficient?
It's continuums of risk, right, David? But I would say the best practice is that they should be as in the post and above. The FTC has said that you shouldn't have to click on more to see the disclosure. So there's a couple ways to do that. You could have it in the image itself. You could have it at the top of the description in a post, so you're not having to click on more. But having it in the bio is generally going to be seen as insufficient, unfortunately. The risk of doing that, using a disclosure just in a bio versus in each post, of course, depends on how strong the claims are in the post, right? So if you're making fairly aggressive income claims in each post, that I think the risk goes up significantly of relying on a disclosure in a bio.
Gotcha. Let's do two more and we'll wrap up. Jonathan, quick question. Is the term extra income being red flagged, or is that a compliance a term?
We've seen variations of supplemental income, I paid for my daughter's dance classes, those kinds of things. They don't seem to get a lot of attention, at least from our vantage point. Some companies have stronger policies than others on those. Some just don't want you talking about the financial opportunity at all. So it really kind of varies from company to company. I don't know the legalities of exactly what can be said because the FTC is so unclear about what you can say. At our compliance and legal events in the past, we've talked about what you can say. We've had several sessions on, well, what can I say? And I think a lot of companies struggle with, okay, I know what I can't say. Here's this list of words and here are all these phrases I can't say, but what can I say? And that becomes a lot harder because there's no clear definition from regulators on exactly what you can say. So we've got with our clients, we've got some coaching cards they can use to kind of tailor that to their company, to their opportunity and products, to say, okay, here's what you can say about our product. And they help the field understand what they can say. And it's, sometimes to the field, it's too watered down. I can't really say this cured my eczema, but it did. And, we can say, well, it promotes a healthy skin, tone, whatever the alternative term might be. So sometimes it's a little disappointing to the field that some of those terms can't be said as they experienced often themselves, or they made more money than most. And so they want to tell people about it. But it just has to be done that way.
Absolutely. All right, Donnelly, question for you from our viewers. What do you think of the suggestion that this decision will be helpful to the industry because the court refused to award anything more than nominal damages for the FTC's allegations of rule violations, saying the FTC could not find actual damages caused by the rule violations, and to allow them to bootstrap, large damages onto the alleged violations would allow the FTC to do an end run around AMG Capital. What do you think about the lack of bottom line financial damages from these rule violations?
So I think I like the question, very optimistic characterization. I'm a glass half full kind of guy. So I see it. I think at the end of the day, it didn't really matter here, right? And the court didn't put a ton of emphasis on that section. So, just to give full background, the FTC had sought, as we mentioned before, had sought damages on these two rules. And the court said, well, look, you didn't really prove what the damages were resulting from the rules. So, I could see companies in the future trying to use that portion of this case as, a way to push back against. We know the FTC is going to try to use rule violations more and more to get consumer redress after AMG. They're going to try to use penalty offense authority notices. They're going to try it all. So I think it's, maybe a small silver lining, but I think the lack of, there are lots of decisions that go both ways as far as how to calculate what consumer harm is. And I think here, I didn't pour over the underlying factual record, but from the court's decision, it sounds like the company and the FTC didn't spend a huge amount of time trying to value what the consumer harm was around the rule violations in particular, right? Because they were focused on the broader pyramiding issues. So I think my answer is maybe a small silver lining if we're being optimistic, but I wouldn't put too much emphasis on it.
Well, I'm all for staying optimistic. So, all right. Well, I want to thank both of you so much for joining me today, and sincere thank you to each of you for watching. If any of you are not receiving Social Selling News and would like a complimentary subscription, please drop me a note. My email is david@socialsellingnews.com. Thank you again, everybody. And thank you, Jonathan and Donnelly, and we'll see you next time.